Thank you so much. Good morning to those of you who just arrived and who were not here for the previous session. We already got started today in the morning at 9 with a session about how to do strategically thinking about litigations to mitigate risks, costs, time, and so on and so forth. We had an awesome dynamic interactive session moderated by John, and John is back again, full power for the next session. I think most of you know me, for those of you who are probably new, because a lot of people were asking me stuff about the event, etc. I'm not an event organizer or manager. I'm one of you, and now this time actually also moderating the whole event, as that is also a part of my passion and profession also as international speaker and educator. So my name is Ewen Tavakoli, not wearing the badge at the moment, but just for the information. Lawyer, business advisor, international speaker, and NFT strategist, collector, creator, and curator, based in Zurich, Switzerland. And I had also a session 2 days ago around NFTs and metaverse and the legal and compliance risks and challenges. And today we'll be also having another session on relevant soft skills for lawyers with other two colleagues as well. So that was short to myself, and my focus is on international contracts, negotiations, international contract drafting, and also dispute resolution, alternative dispute resolution, of course. So that was a little to me, because I got a lot of questions also throughout the past 2 days, and now we are coming to the rock stars of this session around bribery and corruption. Actually, the topic was initiated by myself last year for the conference as former compliance officer of the second Swiss major bank. I faced a lot of issues, and I saw how important and how overlooked or neglected this topic is also in the legal industry. And cases are big, the numbers are high, but the attention is low. So why not talk about it? And we had also a successful session in January, also together with John and 2 other professionals in Dubai. And it went really awesome, and we thought, why not do it again, also in Europe? So this time we are happy to also welcome Simon and Christopher to the session. So I'm gonna leave up the stage to John, Simon, and Christopher to walk us through the world of bribery and corruption. And afterwards, if there are questions, our beautiful Marielle is here. And please do not ask the question without the mic. Otherwise, you will not be in the recording, and there will be a part of the conference missing, which would be a pity. Thank you so much. A big round of applause for our corruption and bribery experts, and let's get into it.
Okay. Thank you very much, Awen. Again, we're going to get into this. We're going to be talking mostly about red flags in the area of corruption and bribery, mostly with respect to, well, we're going to deal with issues of fraud. We're going to deal with issues of corruption and bribery and arbitration, looking at it from both the perspective of the arbitration institutions and a bit from the perspective of the practitioners. I will spend some time talking about how bribery works around the world and how it's being dealt with. But I think let's get started with Simon Jerram, who is a partner at HFW in the UK, and he's going to set the stage for us by talking about issues of fraud and issues of corruption and bribery. So Simon, if you could start us off.
Sure. Thanks very much. Is that working? Yeah. Thanks very much, John, and it's great to be here talking to everybody, and very nice to be in person again after a time of doing virtual remote presentations. I'm Simon Jerram. I'm a partner at the law firm HFW in London. My practice focuses on civil fraud claims, contentious insolvency, and also complex cross-border asset tracing claims. Part of my practice is also dealing with investigations into corruption, white-collar crime, and the procedures that companies need to have in place to deal with anti-bribery and corruption issues. I'm going to talk for a few minutes on bribery and corruption generally, some recent developments, some cases, and with a particular focus on red flags, which is the sort of the key part of this presentation, and what you can do in your ABC policy to resolve those. I'm going to start with just an indication of the impact that bribery and corruption can have on the economy and on businesses as a whole. And you'll see from this slide that some of the numbers are staggering. The first quote there is from Transparency International. The annual costs of international corruption is estimated to amount to 3.6 trillion euros in the form of bribes and stolen money. The second quote there is PwC's Economic Crime and Fraud Survey from 2022, so very recently. And 46%, so nearly half of the organizations that they surveyed reported experiencing some form of fraud or other economic crime within the last 24 months, so within 2 years. And then the UN, every year, corruption losses represent over 5% of global GDP, so that's 2.6 trillion US dollars, and bribes exceed 1 trillion US dollars. So as I say, these are very large numbers. And given the current issues that we have globally, so things such as the COVID pandemic, the Russian invasion of Ukraine, and the stress in the financial markets, including recently in the UK, just mean that, in my opinion, these numbers are only likely to increase. And something, for example, that we're seeing a lot of is, say, accounting fraud. So you'll all have heard of the Wirecard investigations and the issues that arose with Patisserie Valerie in the UK. And there are, as we'll come on to, sort of red flags in those kind of cases that people really need to look out for. But combined with this, and combined with the increase that we've seen in these numbers, there's been an increasing focus over the past couple of decades globally on anti-corruption. The US Foreign Corrupt Practices Act is now coming up for 50 years old. The UK Bribery Act, 12 years old. And so whilst these numbers seem very high and are increasing, there is a focus on this globally. I'm just going to take two examples, just briefly, which we might come back to later in the discussion as well. One of these sort of shows bribery issues, and the other shows red flags. Now, the first one, as you might know, that's an Airbus. So this is the Airbus case. And if we think back to 2012, Airbus carried out an external review of its anti-bribery and corruption program, and it was even awarded a certificate for the design of its anti-bribery and corruption program. As it appeared later, during that period, and for the period 2011 to 2015, Airbus was involved in serious criminality in a number of different jurisdictions through bribery by Airbus business partners in various different jurisdictions worldwide. And if we fast forward to 2020, Airbus agreed a global settlement with various regulators in different jurisdictions, by which it agreed to pay over 3.5 billion euros to those regulators. And in the course of agreeing in the UK a deferred prosecution agreement with the Serious Fraud Office, the judgment that was handed down by the judge in approving that DPA, deferred prosecution agreement, said, and this is a quote, Airbus had a corporate culture which permitted bribery by business partners and or employees to be committed throughout the world, and where bribery was, as I say, quote, endemic. Now, there's now civil litigation flowing out of some of these sort of cases, including Airbus. And it's funny enough that we are in the Netherlands at the moment, because earlier this year, there was a case that was filed in the Dutch courts against Airbus by institutional investors. This is a class action by institutional investors, claiming at least 300 million euros in compensation in damages because they bought shares that were overpriced as a result of issues that should have been disclosed, or they say should have been disclosed, but were not. And in those proceedings, KPMG and Ernst & Young, EY, are also named as defendants. The second case I'm just going to talk briefly about is Madoff. So you'll probably be aware of the Bernie Madoff Ponzi scheme. And this shows that it's important to pay attention to red flags, because if they're spotted early, it might save a lot of harm worldwide later on. And I'll just say at the start that although you may see red flags, it doesn't necessarily mean that in and of itself that bribery and corruption is present. It just means that you should pay increasing attention, make sure you're dealing very carefully with the issues, and that you're recognizing these in your anti-bribery and corruption policy. And just to start with what we mean by red flags, and I probably should have mentioned this earlier, it's matters or information or a situation that might indicate a potential compliance concern at a third party that you're dealing with or even within your own business. And there were numerous red flags in the Madoff Ponzi scheme that people should have been aware of, and in hindsight, everybody says, well, why on earth did we miss those? Now, some of those are specific in the Madoff case to financial trade, and I'm not going to touch on those, but there are some others which are applicable more widely. First, secrecy. Bernie Madoff demanded secrecy from everybody who gave him their money. Now, he said, if you have a normal business, which is a very successful business, you're not going to be really secretive about that and say, oh, don't tell anybody about this. It's unique to you, but don't tell anybody about it. You're not going to be telling them about how you're doing the work and how you're making so much money, but you're not going to be saying, this is massively secret. That should have set alarm bells ringing. And connected to that, there was exclusivity. So Bernie Madoff said to everybody, oh, I'm not taking on any other investors at the moment, but you know what? You're so special, you can come and join the club, so it's okay, I'll let you in. Now, both of those, secrecy and exclusivity, should really have raised red flags to potential investors. And Bernie Madoff was very clever, because if he said, if there was somebody who was a smart investor and they started to raise questions, he'd just shut that down automatically and wouldn't be concerned that they weren't invested. He was more keen to sort of get the others who wouldn't ask questions and were willing to sort of be secretive. Second key red flag, consistent high returns and low volatility. So if you invest in any asset, funds, or anything else, you expect your investment to go up and down. The Madoff Ponzi scheme didn't. It showed a consistent sort of 45-degree incline. And that's probably the most simple red flag that people should have noticed and should have tipped off both investors and also the regulators worldwide. And finally, another red flag is third parties. We'll come on later, maybe in the sort of discussion topic, to talk about sort of the enhanced due diligence you might want to carry out on third parties. But one of the third parties involved in the Madoff Ponzi scheme was an audit firm. Now, the audit firm was a one-partner firm with offices, I think, on a back street in New York, which for 15 years declared that it did not do any audit work. And it would have been obvious that they lacked not only the resources, but also the expertise to be able to carry out the audit work for a multi-billion-dollar operation. So what can businesses do to mitigate their bribery and corruption risk? And I'm going to talk about this just briefly in two separate categories. Firstly, culture. And that means that the entire business, the entire operation is set up to address and manage the fraud risk that all businesses face. And this is the opposite of what you see, and from that quote, which I think I mentioned earlier, about the Airbus situation, which had a culture that permitted bribery, or said to have a culture that permitted bribery. It's also the opposite of what you see has been reported in relation to Wirecard, where Wirecard's entire operations were focused on growth, and their modus operandi was to attack anybody who criticized what they were doing, even so far as to subject the Financial Times reporters who were investigating the Wirecard situation to criminal investigations in Germany. And just one or two points to consider in relation to what I mean by culture. Firstly, a tone from the top message, which is from senior management saying that this is the bribery and corruption issues are wholly unacceptable, and that needs to be continually re-emphasized and updated. And for example, at the key times in the year, such as, say, Chinese New Year or Christmas or those sort of times, you may want to re-emphasize that message. A zero-tolerance approach. So if there is bribery or corruption issues, they need to be stamped out urgently. If management need any help in sort of deciding that this is an issue that they really should address, there was a paper by the accountancy firm Crowe, which was published a couple of years ago, which said that the fraud losses, I gave some global numbers earlier, but the fraud losses in any given organization amount to at least 3%, probably almost 6.5%, and possibly in excess of 10% of the business's bottom line. So it has a substantial impact upon a business. The management may also want to set up internal committees, and it has to communicate its culture both internally and externally. The second point about what businesses can do is set up procedures which need to be in place. And of course, every business needs to have an anti-corruption procedure. And it's important, as you'll see from this first quote from the UK's Serious Fraud Office, their paper on evaluating a compliance program, it says that a key feature of any compliance program is that it needs to be effective and not simply a paper exercise. And you'll also see that they go on to say that it is critical that the compliance program is proportionate, risk-based, and regularly reviewed. So just taking each of those in turn, proportionate. Each business is different, and even as the business grows, what is proportionate will be different. So I mentioned Wirecard earlier. In 2010, what may have been, or the early 2010s, let's say, what may have been a proportionate compliance procedure was very different to when Wirecard started to grow sort of exponentially from about 2017 onwards. Risk-based. I was speaking to a regulator at a bank a little while ago, and they said that the only way to mitigate risks in the banks is by shutting them down altogether. Now, clearly, you're not going to do that, and a business is not going to shut down. But what you need to do is manage the risks, and your policy needs to be risk-based. It also needs to be regularly reviewed. So not only to take account of sort of changing macro factors and micro factors, but also to address new risks, new issues that the business faces. For example, opening up in a new jurisdiction, doing business with a different entity, as I said, Wirecard growing exponentially, that sort of thing. And part of this is going to be the policies that are in place, and a whistleblowing policy, for example. That needs to be effective and properly managed and ensure that employees and individuals can come forward with potential bribery and corruption issues that arise, and they must be able to report those. There must be no fear in making those whistleblowing reports. There must be protection and confidentiality for them, and there must be a reasonable time frame in which there must be a response to any whistleblowing reports that are filed. If and to the extent there's a breach of the policies or some sort of bribery and corruption issue does arise, that needs to be dealt with promptly and actively, and that needs to be set out in the policy as to how you're going to deal with that. And that includes, where necessary, cooperation with regulators. And that will be a key factor. Various regulators have said that the extent to which you cooperate will be a key factor in determining whether or not we, as in the regulator, makes charging decisions. And I mentioned the Airbus case earlier. In the Airbus case, whilst there was initially what was described as a slow start, Airbus later provided what was called its fullest cooperation, and that probably helped it reach a settlement at a level that presumably was acceptable for it. And then just finally, the policies and procedures, and coming back to the sort of focus of this talk about red flags, the way in which the red flags are addressed is key to how effective the compliance program is. Red flags seek to prevent, identifying red flags, seek to prevent bribery and corruption issues at an early stage. Now, if you look online, you can find some examples of what red flags may need to be addressed in your ABC, anti-bribery and corruption policy. For example, Lockheed Martin, a very large US arms aerospace defense company. If you look at their website, you can find their ABC policy. You can also find a list of what they identify as red flags. Now, that is a 4-page document with very closely typed bullet points, all setting out each individual red flag, which may be potential red flags. That might be too far, obviously, for some businesses. And as I say, it needs to be, as this slide says, risk-based, proportionate and regularly reviewed. But that just shows sort of the extent to which you can identify these things in your ABC policy. So that's the end of my time. Thanks for listening, and we'll have some discussion later, I think.
Okay, thank you very much, Simon. Christopher, why don't we hear from you from the perspective of major arbitrations?
All right. Perfect. Now everything seems to be in place technically. Thank you very much, John, for the introduction, and I also want to extend my warm thanks to the organizer of these events. We certainly have had a lot of interesting panels and have a lot of interesting panels to look forward to, so I'm very happy to be here. My name is Christopher Hedberg, and I am a legal counsel at the Arbitration Institute of the Stockholm Chamber of Commerce, and that name is quite a mouthful, so we go by our abbreviation, which is the SCC. So coming from an arbitral institution, my ambition here today is to give you an introduction of the topic of corruption in arbitration, and specifically with the perspective of an arbitral institution. So to sort of frame the discussion and give you a picture of where I'm coming from, I want to start with just a short background telling a bit about the SEC. Whoops. I got a spoiler alert.
Is it okay?
Yeah, let me check here. There we are. Perfect. So now we're back. Give you a short background about the SEC as an arbitral institution. So we are quite an old institution. We're established already in 1917, so we're a bit over 100 years old. We started off, as most arbitral institutions do, as a national institution with mostly domestic cases, but over the years we have evolved into a truly international arbitral institution. And today we get about 200 new cases per year. About half of them are international and half are Swedish. And we see parties with about 40 different nationalities in our caseload every year. Looking at our caseload, it is quite diverse, but you can see some characteristics being present, and these are, some of them are mentioned on the slide here. We have disputes with an east-west angle, we have energy-related disputes, and we have investments arbitrations as being prominent in the caseload. And for those of you who are not primarily arbitration practitioners, investment arbitrations are arbitrations which are based on bilateral investment treaties, where an investor makes a claim towards the, or against the country where the investment was made. So it's a bit different from commercial arbitration. At the SEC, we maintain a set of different rules. The primary rules are our arbitration rules and our rules for expedited arbitration. Under both of these rules, the SEC administers the dispute, meaning that we make certain procedural decisions, we decide on the costs of the arbitration, we appoint the whole or part of the tribunal, but the case on the merits is in fact decided by the arbitral tribunal. And then we have some other rules as well that you can see on this slide. So to further frame my input into this discussion, I just wanted to give you a brief glance of this slide, which sets out the life cycle of an arbitration under the SEC arbitration rules. So what you can see here is that we are basically working with two phases. A preliminary phase where the case is handled by the SEC. That is where we receive the request for arbitration, we receive the answer to the request, we make any procedural decisions necessary, and we appoint the tribunal in whole or in part. The case is then referred to the arbitral tribunal, who then, like I said, decides the case on the merits. And then the final background slide. This sets out some of the core principles in the SEC rules, because I think when approaching a subject like corruption and red flags and looking upon that issue from the perspective of an institution, we must first clarify what is the role of arbitral institutions in arbitration. And basically, our role is quite simple. We are a neutral venue for the parties to come to resolve their disputes in an efficient and expeditious manner and to get an end result, which is a high-quality enforceable arbitral award. So therefore, these key principles are set out in the SSE rules. We see first that we are obligated to settle dispute in an efficient and expeditious manner. But while doing this, we must also make sure that the arbitral award rendered by the arbitral tribunal is in fact enforceable, because this is obviously the end result that parties want, an enforceable award. The the third principle is what we call, we apply what we call a light touch approach, meaning that once the case has been referred to the tribunal has quite a wide mandate to manage the arbitration as they see fit. So, having that background in mind, we now approach the core subject matter of this panel, which is corruption in international arbitration and red flags. So starting off, I think that it's useful to ask ourselves what corruption really is. And of course, Simon has already talked a bit about this. And the takeaway is I think that corruption is quite a wide expression. There's a lot of different conducts that goes into the umbrella definition of corruption. But the most relevant and most straightforward form that we oftentimes see in arbitration as well will be bribery. And obviously bribery has a number of different definitions as well, but there are somewhat of generally accepted definitions found in different international conventions. When we speak about corruption in arbitration, then usually the case that comes up is that corruption can or has occurred either in the procurement of an investment or a commercial contract, or that the contract or investment itself provides for corruptions. So those are basically two different cases of corruption that we see in arbitration. And usually how it comes into play is also a bit different if we're speaking about investment arbitration or commercial arbitration. In investment arbitrations, it is not unusual to see corruption being raised as a defense by the host state, the defendant state, saying that corruption was involved in the procurement of the investment, and therefore the tribunal lacks jurisdiction over the case, or the investment should not enjoy investment protection under the relevant bilateral investment treaty. In commercial arbitration, I would say that the most common situation where corruption will be alleged by a party is when it comes to different agency or intermediary agreements. So these are basically agreements where you have a middleman being employed in order to, for example, procure a government contract or to procure a license to make business in a certain country. In those situations, you can see disputes about, for example, the commissions to the agent and corruption being raised as a circumstance against the request for commission, for example. So looking at how corruption as an issue comes into arbitrations, it can do so basically in two ways. The first way is due to an allegation of corruption from a party. So if a party make an allegation of corruption as part of the case, like I said, for example, as a defense, jurisdictional defense or a defense on the merits. The second way, which is a bit more controversial, is for the tribunal to raise the investigation or the issue of corruption by their own initiative. This is usually called a sua sponte investigation. And like I said, it is a bit more controversial. There has been a lot of discussions whether the tribunal can and should do this or not. Proponents for sua sponte investigations hold that the tribunals are allowed or even obligated to make such investigations if there are certain facts brought forward the parties which indicate corruption. So this is where red flags could come in, for example. These could be something that could trigger a sua sponte investigation. An argument held by proponents of sua sponte investigations is oftentimes that this is necessary for the tribunal to take into account in order for the award to be in line with public policy and therefore enforceable. The people that argue against sua sponte investigations often hold that the tribunal raising this issue of their own mandate would amount to an excess of mandate, which could lead to the award being challenged or declared invalid at a later stage. But these are the two ways that corruption can come into arbitral proceedings. And this brings us, I think, to the legal consequences of a finding of corruption. So corruption, either if it's brought by a party as an allegation or is lifted up due to the tribunal's own initiative, if corruption is proven, then the legal consequences of a finding of corruption will, to give the normal lawyer answer, it will depend on the applicable law to the dispute. So the law chosen by the parties and perhaps even the public policy of the seat or the place of performance, or sometimes it's even argued that corruption is such a threat to society that it's part of a transnational public policy which transcends national regulations. But in general, I have listed some consequences of a finding of corruption here, which I think are the consequences that will be most relevant usually. In investment arbitration, we see, as I mentioned, a potential lack of jurisdiction. And the reason that this will be the case in investment arbitrations but not in commercial arbitrations are due to the principle of separability in arbitration, which says that even if a commercial contract is declared null or void, for example, then the arbitration agreement is a separate agreement which survives that declaration. So there's no problem of jurisdiction there. So when it comes to commercial arbitration, instead, we're mainly talking about consequences such as inadmissibility of claims or rejection on the merits due to the contract being declared null and or void. So this brings us to red flags and the question of what red flags are in arbitration. Of course, Simon has told us a lot about red flags and what they sort of mean in more of a general context. And I think that a lot of the red flags will be the same in arbitration, but at the same time we have a bit of a different situation because now we have a dispute and we have an arbitral proceeding to deal with. So basically the red flags in arbitration, what they can be used for is that they can be, like I mentioned before, an indication for the tribunal to make further investigations into the issue of corruption. So this will be, prima facie circumstantial evidence, or not evidence, but circumstances that the tribunal can look at and say, hey, maybe this is something that we need to investigate further. Another discussion is that circumstantial evidence in the form of red flags can have an effect on the burden of proof and the standard of proof. And basically the reasoning behind this is that corruption obviously is something that is quite difficult to prove, and often there will be a lack of direct evidence. So some tribunals or some people think that this should result in the burden of proof being shifted from the party alleging corruption to the other party upon presentation of prima facie evidence, for example, in the form of a set of red flags. Similarly, some people think that the standard of proof should be lowered when it comes to allegation of corruptions, but a lot of people do not agree with this and say that corruption is such a serious offense that clear and full evidence would be needed in order to make a finding on corruption in arbitration. And I think the general view at this point is that most tribunals would say that the burden of proof should not be shifted and the standard of proof should not be lowered. But at the same time, the general view seems to be that a certain amount of circumstantial evidence, including, for example, red flags, can be sufficient to make a finding of corruption, taking into account the difficulty of proving corruption via direct evidence. And when it comes to what the red flags actually are, like Simon said before, there probably are a lot of red flags to take into account. And what red flags are relevant will depend upon the facts of the case. I have listed some red flags on this slide, which are actually found in a toolkit for arbitrators to deal with corruption, which I think is quite useful. And the first set of red flags has to do with situations that I talked about before, where you have an intermediary or agency agreement in dispute. And there you can look at a number of different factors, such as that the commission of the agent does not seem to be corresponding to the work actually performed, that the qualifications of the intermediary are perhaps doubtful, the financial statements of the intermediary might be not entirely in place either. The intermediary might have personal connections to decision makers, and I think the last one is an important one, that there might be a lack of a clear and specific contract what the intermediary is supposed to do, and also that the employment of the intermediary perhaps cannot be rationally explained when you look at the commission paid. Then, of course, there are red flags which relate to situations where we do not have an agent or an intermediary, and there you can usually look at broader circumstances. So, for example, the attitude of a specific company towards regulations as a whole. What are they doing? How is their policy looking? If there has been criminal investigations by a state already, or there might have been criminal findings already, or a number of other factors as well. So, what I have talked about so far when it comes to red flags and the burden of proof and all of these material aspects, this is obviously something that these are decisions to be made by the arbitral tribunal in the second stage of the arbitration that we saw on the slide. So an interesting question to ask, especially for me, I think, is what can arbitral institutions do? Looking once again at the principles and our objective in the arbitration, because obviously the primary objective for us is to enforce the arbitration agreement of the parties, meaning that we oftentimes in an initial stage of the proceedings cannot do an in-depth legal analysis of the transaction of the parties to see if there is any corruption there. So I think but on the other hand, as I mentioned previously, we also have an obligation to see to that awards are enforceable, which they may not be if the transaction in dispute is tainted by corruption. So I think that one thing that we can do, which is a bit more on the soft side, is to raise awareness of corruption as an issue in arbitration and to highlight this issue for arbitrators and practitioners. The other thing, which is a bit more concrete, is that we can see to that we appoint arbitrators who are specially equipped and have the knowledge necessary to deal with corruption in arbitration. I think this is a very important one. The third thing is that we can act as a point of contact for arbitral tribunals, so be able to support them when they look at the case and the case materials, and perhaps even convey information that we have found about the case. But obviously here we have to be quite cautious so that we stay impartial and neutral in the dispute. So that's it for me. I hope that this has given an introduction to corruption in arbitration and a perspective from arbitral institutions. I look forward to the continued discussions.
Okay. Thank you very much, Christopher and Simon. My name's John Lowe. As you know, I work as an arbitrator and mediator. I have a presentation which you will be free to look at your leisure. I'm not going to go into that presentation right now because I'd like to spend some time talking mostly about red flags. What you've heard from Simon and Christopher's presentation is that there's a nexus between allegations and proof of fraud in what I will call commercial dealings, investment dealings, and then it moves right into allegations of corruption and bribery in with respect to government investigations. Simon mentioned the fact that we're now 50 years into the Foreign Corrupt Practices Act. I'm going to date myself because I actually remember the Foreign Corrupt Practices Act coming into effect in the United States. I was working as a diplomat then, and we were trying to assess its impact on U.S. companies doing business overseas. This was in the early 80s, and the impact was, there was some, but not too much. The American companies were complaining that they were being signaled out and that all the rest of the companies around the world could do whatever they want. 20 years later, let's move on. The rest of the world started catching up with the OECD Anti-Corruption Convention, and then subsequently the UK Anti-Bribery Act, which came into effect about 12 years ago. Even France came along with the Loi Sapin 2 most recently. And actually, most European countries and a lot of countries have gone into corruption and anti-bribery laws. So there's been a change in the landscape, and there are a lot more government actions right now. Simon mentioned the Airbus case, which I frankly find amazing, because I remember back in 2010, 2012, Airbus was lauded as having a very comprehensive reaching into all parts of the company, anti-corruption and anti-bribery program, huge compliance department, huge compliance efforts. And what happened? At the same time, they were bribing all over the world. It was a bit incredible, which is also why they ended up paying 3.5 billion euros, which is a lot of money, even for a company like Airbus. The other thing I wanted to mention is, and again, moving into what Christopher said, as we see government investigations of anti-corruption and bribery taking place, this has spilled over into the arbitration world, mostly with respect to investment arbitration, but also with respect to normal commercial arbitration. And I am going to pull up, I have something called an FCP, an anti-bribery handbook. This is published by Hughes, Hubbard & Reed, which is an international law firm. They actually were advisors to Airbus. But there are a number of law firms that are putting out these studies or summaries of anti-bribery actions around the world right now. Another one is called Miller & Chevalier, which is a Washington-based firm. And what is interesting about this, what is interesting about these is mostly they deal with what are the results of government investigations into briberies, what are the results, the penalties paid, who goes to jail or not. But I think from my perspective, as an arbitrator and mediator, what I find most interesting is the facts that they go into. What happened? How were the bribes being paid? We mentioned agents and consultants. Agents and consultants figure prominently in the world of bribery. Now, I have a question I wanted to ask. If anybody wants to comment, if you were setting up a bribery program for your company, how would you go about doing it? Does anybody want to answer that?
Look at other companies, how they do it, and use their intelligence and don't reinvent the wheel.
Exactly. And let me use an example from my personal experience. It was a company called Alcatel. And this is all in the public domain right now because they entered into a deferred prosecution agreement with the U.S. Department of Justice. But I worked there for about 12 years. What they did, and you could say this was a French company doing this. On the other hand, this French company bought the telecom subsidiary of an American company, and they basically just took over an existing system. They had a big system of using agents and consultants around the world. All the contracts were run out of a Switzerland subsidiary. Why Switzerland? Very comprehensive privacy laws. You didn't want anybody looking into it, so do it in Switzerland. So all these contracts were essentially consultancy contracts. The consultants were paid when Alcatel was paid. How the consultants were managed varied a lot. But at the heyday, probably 5 or 6% of Alcatel's turnover was being paid to these consultants around the world. What broke the dike was investigations in Costa Rica, where Costa Rica found out that a number of ex-presidents had actually been receiving payments from Alcatel, commissions on telecommunications projects of approximately 17%. 17% is pretty heavy. Normally, agents and consultants for big projects, you're probably talking 1 or 2%. So there was a fairly significant margin there. And you're looking at how agents and consultants work, and again, you see this throughout. You know, they can be paid, you know, some of them are just 1 or 2 people. Some of them are actually, you know, there are exceptions to the rule. I worked with a very good agent in Israel that had several engineers on their staff. They had salespeople on their staff. You know, they worked very hard for their 5 to 10% of the commission. So it varies a lot, but what happens is companies need to, or governments look very carefully at this. Right now, there are whistleblower provisions around the world. In the United States, what can happen is a whistleblower can go to the Securities and Exchange Commission. They can say, for example, company X is bribing people around the world, and if they are successful and if that results in a prosecution, the whistleblower can be paid an enormous amount of money. So companies need to be much more careful right now. Another thing that is happening is you're looking at how companies deal with what are called third parties. Know your customer, know the people you're dealing with right now. I don't know, some of you are probably working as in-house counsel. I'm actually doing a short assignment as in-house counsel for a company, and I am amazed at, you know, setting up a new account with American Express. They want passports for all the directors of the company. They want proof of address for all the directors of the company. It is very time-consuming and annoying, but it is their process for ensuring that they are dealing with a proper company, properly organized. It's know your customer, and it's make sure that the people you're dealing with are bona fide business people, bona fide investors, what have you. Another thing that's happening is that companies, when they get into contracts with other suppliers, for example, a provider of gas turbines who is dealing with a freight forwarder. What they may do is they have a comprehensive contract. They will put into that contract provisions in which the supplier, the freight forwarder, commits to having an anti-bribery compliance program. They will also commit to being open to having that anti-bribery and compliance program audited by the customer. So you are seeing a lot more of this, and let me tell you, the companies that are putting forward these contracts, they are actually following through on their what I will call threat or promise to audit the internal compliance program of companies. And that is happening. It's happening on a much more regular basis. Now, I wanted to move into also the nexus between arbitration and corruption, because as you're seeing all these red flags come up around the world, you're also seeing arbitrators being faced more and more with questions of corruption related to the contracts, related to investments. Christopher has mentioned these both in the context of investment arbitration and in the context of commercial arbitration. And I will also note that this handbook, the last part of it, of about 30 pages, 40 pages, deals with issues of corruption in arbitration proceedings. So they are coming up a lot. One thing Christopher mentioned was whether arbitrators should actually, on their own, sua sponte, start asking questions about corruption. You know, this is actually not being led by the arbitral community itself. it's arising because I would say particularly the French courts are really telling arbitrators that they have to do this. And if they don't do this, they are risking having their arbitral awards vacated or overturned at the French level. And this has happened. There was the Alstom case, an Alexander Brothers case, where the arbitral award was at. I think this is in my presentation, so you'll be able to get some references to it. But basically, the French Court of Appeals was saying, you know, arbitral tribunals really do have a responsibility to look carefully into this situation. I think there was one other point I was going to make, and again, this goes into the compliance area, but things are changing around the world, and one thing I think Simon brought it up, and I want to just, is in the area of gifts and representation. And again, 20, 30 years ago, you know, companies were spending huge amounts of money on gifts and representations at Christmas time. 3 or 4 years ago, I had a lunch with the general counsel of a big French defense contractor. He said, you know, John, we decided to cut all that out. He said the salesmen were crying to me saying, you know, we're going to lose all these contracts. We're going to not have any more business with these guys anymore. He said, we stopped paying, we stopped giving Christmas gifts. We got rid of 5 million euros in expensive, and nothing happened. Nothing happened. So, you know, this is happening around the world. The good old days when your customers used to expect to be taken to fancy restaurants and great hotels in Paris, and I remember those days, that's gone. That's gone. So there are changes. There are changes. People will say that the Chinese don't really go in this area anymore, that they're sort of the exception to the rule. Probably so. But at least there are lots of changes going on around the world. Listen, I've spoken a little too long. I want to open up to some questions. I have some questions for the panelists as well, but let's hear from questions back there. India, can she have a microphone?
Thank you very much. John, you touched on this with criminal prosecutions, but I'm wondering, practically speaking, and you know, obviously we hope this doesn't happen to us, but 2 parts. If you realize as a practitioner that your client has engaged or is intending to potentially engage in corruption or bribery, what should you do? Do you have reporting obligations to an agency, or and I suppose this depends on the jurisdiction, or to a judicial body? And then on the other side, if you become aware that there has been corruption, bribery, etc., on the other side by a lawyer, defense counsel, or whoever, potentially an arbitrator, whoever is a lawyer, do you have reporting obligations to, you know, a licensing committee or whoever, produces the bar, essentially, of the lawyer, or to a criminal body that might prosecute that lawyer? So basically, what are your obligations if you find yourself practically in this situation? Thank you.
Frankly, Simon, why don't I let you take this?
Yeah, thanks for the question. Yes, I mean, there are let's take the UK as an example. If you come across some sort of corruption or bribery issue or some sort of anti-compliance issue, you may, depending on, it depends what you find out, yeah? So in certain circumstances, you may just have a red flag, and in those cases, you need to consider quite carefully about to what extent you need to investigate that further. If it goes further and you actually do know for a fact, or you've been told that that's gone on, then you may potentially, because then there's an issue as to whether or not you can receive payment, and you should actually then make a disclosure report to, say, the UK authorities. I think the only other thing that I'd just add is and I think the same is true under the Foreign Corrupt Practices Act, but under the UK Bribery Act, it's a strict liability offence of failure to prevent bribery under Section 7 of the Act. And so that is, regardless of the extent to which you're involved, regardless of the extent to which you had any knowledge whatsoever, you can still be liable for that. And that's why you have to have those procedures in place that I was talking about. So as a law firm, as a practitioner, you need to have your own policies and procedures in place to try and prevent that arising early on. Do you want to talk from the arbitration perspective, or?
I don't think so. I think the question related to more of what you touch upon, so being a practitioner, what you do.
Let me just say a few words about that from the point of view, and I've been there and done this, of, let's say, a chief compliance officer for a company. You have to be very careful about this. I have a colleague in France, Jean-François Lenné, who was the chief compliance officer at Alstom. And right when he was starting, he signed off on a contract, I think it was related to Hungary, which actually became the subject of a serious fraud office investigation in the UK. As having signed off on this, he was subjected to criminal investigation. The case went on for 3 or 4 years. Needless to say, his consulting business was seriously damaged. He was actually eventually exonerated, but you know, when you are advising, either as an external lawyer or as an in-house counsel, companies with respect to corruption and anti-bribery issues, you need to be very careful. And if issues arise, you need to start moving them up the chain very carefully. Most jurisdictions do give credit to companies that self-report potential violations or actual violations. So in this type of situation, if I were an in-house counsel and aware of a violation, I would certainly move it up the chain of command and strongly recommend, depending on the circumstances, that we go ahead with self-reporting, and again, deal with the consequences emanating therefrom. The risk for a chief compliance officer is if you don't do that, you can be in the situation of Mr. Lenné facing criminal charges yourself. So it is a complex area and one that needs to be dealt with. Other questions? We've got questions over here. Right behind you.
So I have 2 questions because I have the same background as well, and I know also the challenges and the gaps, why these anti-bribery and corruption programs were not working the way we or the companies wishing them to do. One question for me that those days could not really be resolved also by the bank was how can we encourage or maybe provide incentives for whistleblowers so that they do not feel like they are betrayers? Because they are being somehow stigmatized that if somebody is going to whistleblow something, they are being considered as, yeah, betrayers or not cool people or people who are not really supporting the business. So that is one question, which I think maybe not the more important one, and then I...
Listen, I'm going to pass that to Christopher because Sweden has just enacted a new whistleblowing or compliance law. I don't know if you're aware of it, though.
Thank you very much. I am briefly aware on quite a shallow level. It might be that Simon knows even more than I do on that. But I would say from my perspective, not being an expert on the whistleblower aspects, but still, I think a lot comes back to this, besides having, you know, a good legal framework where people can be protected and feel safe and so forth, a lot probably comes back to what Simon said. I mean, it's a matter of culture, isn't it? So it's a matter of creating a culture and internal structures where whistleblowing can take place in a good manner. And there's probably a lot of components that goes into that, but all of them probably relates to like you said, not making people feel unappreciated or exposed in that setting.
So just to add to that, I mean, I was talking about a whistleblowing policy that needs to be in place at organisations, and I think various jurisdictions around the world, not just Sweden. I think there's an EU whistleblowing directive. There's various different other bits and pieces on whistleblowing, and it's something that people are looking at quite strongly. I think just in terms of sort of how you actually deal with it, I think there's a bit of a balance to be struck, because on one level, you obviously can't, you must not attack the whistleblower or treat them as a betrayer, as you suggest. But on the other hand, you don't want to have it so far to the other extreme that you actually reward them for doing that, because then you end up with so many potential things that come up, that actually it needs to be very much protection for the whistleblower if and when the report is made. So I think it's a bit of a balancing act. But yes, I mean, it's all dealt with in policies and procedures.
Yeah, thank you. I have a question with regard to building culture and tone from the top from a compliance perspective. And my experience is you have all of these policies in place. You have a very robust compliance program. You have the tone from the top. Senior leadership saying, okay, compliance is extremely important, anti-corruption, etc., etc. But at the same time, all businesses ultimately want to make money, and you might get, especially as a, let's say, without wanting to say this negatively, but to say as a lower level employee, maybe a sales rep or something like that, you get a lot of mixed signals, right? Your incentives to work in an organization are strongly financially led. You need to achieve a certain level of sales, and at the same time, you do all of those anti-corruption trainings, etc. Now, my question, I personally, I don't have an answer to that, but how can you, just from a practical point of view, make sure that indeed that balance is struck rather on the, let's say, more compliance-friendly side than the more sales-friendly side? And I think, from a perspective as a legal counsel, I mean, that answer is pretty clear, right? You will always try to enforce the compliance side. But how do you get through to those sales reps, for example, to get them on the right side?
So as you say, I think it goes to culture, and it comes directly, as I was saying earlier, from the top. I think it also goes to the way in which you reward, say, those salespeople. If you reward them for the massive new business that they bring in, then that's more likely to engineer a situation in which they're more likely to do something that's slightly suspicious. Whereas if you reward them more on a long-term, how much they've made over a number of years or whatever it might be, and less bonus, etc. And that's something that certainly there's been a lot of talk about in the UK in terms of banking as well. And it's just going back to the way in which people are rewarded for the work they carry out, and as I say, make it come very much from the very senior management. I was giving some figures earlier from the Kroll report where it was saying you can expect the losses amounting to fraud to, in some instances, above 10%. I mean, management have got a big incentive to make sure that these issues are minimized, and people should take heed of that.
Let me just add a couple things to that. One, as you start looking through the various prosecution arrangements and deferred prosecution agreements, you will see, and I tried to mention this with the Alcatel, is setting up a bribery program is not easy. It needs some work, it needs some attention, and it also, by putting in proper controls, proper financial controls, for example, false billing, overbilling, and getting kickbacks. Putting in good financial controls, putting in good contract procedures, that actually can help deal with a lot of things. Because if you don't give, speaking very bluntly, if you don't give your salespeople the tools with which to bribe, they're not going to be able to bribe.
So, nowadays, everything is being fast, as well as the laws and regulation is being updated frequently from time to time. So what is the best solution to comply with this updated laws? There is, for example, in your home country, there is a platform or the website that publish each updated regulation, or what you can comply with this all updated regulations?
There isn't a platform that you're describing where you can easily kind of ensure that you're up to date. I think, but it's not just, when I was talking earlier, I was saying that you need to ensure that your policies and procedures are regularly updated, and that's certainly right. But it's not just for changing regulations, so legal obligations, it's also changing how your business itself actually changes and is moving around. So if, as I said, if you're opening up in a new jurisdiction, or you've suddenly got a big line of business from a new client, your due diligence that you're carrying out might need to be renewed. But on the keeping up to date with changing rules and regulations, I think the only way you can do that is by taking advice.
No. Just to say that I agree. I was just nodding, basically. I think that taking advice is probably the best advice.
I haven't heard any of the speakers refer to in-house counsel extensively, and I think they play a pivotal role in fighting bribery and leading the pack in compliance. John, you've been in-house yourself. I mean, have you watched noisy withdrawals by in-house counsel because there were situations where management wanted to go a route where everyone should know because they've learned it in kindergarten what is right and what is wrong, didn't behave?
It's an excellent question. I have not seen noisy withdrawals. Given where I worked, you might have expected some. I have, and again, this one comes to mind because it came out in the government investigation, but when I was general counsel, I did nix contracts with excessive amounts for consultancy fees. And basically, my reputation then was that if I said no, it stopped. But that was in one part of the company. What happened in other parts, I don't know. But it is difficult. And as I mentioned, in-house counsel right now are potentially liable and could be liable criminally. And what is happening on an enforcement basis is that enforcement agencies are looking more carefully, not only at companies, but at actually the perpetrators of the bribery scheme.
I think just on in-house counsel, I think they're the sort of first line of defense often when you've got these issues that arise. And so they're really important, and it factors into what we were saying both about whistleblowing and ensuring that there's protection for whistleblowers, which is hugely important, but also for the in-house counsel, and that people are incentivized, and that goes back to how people are rewarded to refer things to in-house counsel if there's any issue or if there's any red flag that they're aware of. So I think, as I said, first line of defense, and there needs to be a lot of protection for in-house counsel.
Thank you very much, Christopher and Simon. This was a pleasure working with you, and if you have any questions, they will be around.